All right, good afternoon, everyone. Welcome to, I guess this is the last session that we stand in the way between you and the reception that's awaiting us. So we will be mindful of our time. I'm Ed Chen. I'm a district judge of this court, for those of you who don't know me. And I was asked for some reason for reasons that won't be apparent, to moderate this panel on multi-state classes and collective actions and subject matter jurisdiction. Not the kind of thing you'd want to go to a cocktail party with non-lawyers and have a conversation with. But the fact that it's a mouthful, just to give you the title of this panel, suggests that there's a lot to talk about. And so to talk about it today, we have two very experienced class action and litigation attorneys. Kevin Budner is with Leaf Razor, who's going to present one side of the presentation, and Megan O'Neill with Detail Law, which she founded, will present. And she wants me to make clear that even though she's with a small firm, she represents the D side, not the P side. So we are evenly matched here. And what I hope to do is to reserve, 10 or 15 minutes at the end for questions. But we have a number of things to cover. So let me just first say, maybe you've heard all this. I wasn't privy to the three other panels. But as you probably know, the Northern District is a hotbed for class actions and collective actions. I think one stat that I saw recently revealed that between us and Southern District in New York, we have about a third of all class actions filed in the country. And I don't think that accounts for all the MDLs that we have. I think I and all my colleagues know this because it seems like every other week we're either looking at a class cert motion or a motion for preliminary approval of class settlement or motion to decertify the class or something or not. And so it's quite often that we see this. And so we appreciate how important these cases are and how complicated things get. And multi-state class actions are something that I think we see quite often, and maybe even more often than before. They're complicated, but they take all sorts of forms. I've had, for instance, defective products cases involving automobiles, emissions issues, defective engine, defective software kind of questions. I think Judge Lynn has a Scandus case that you may have just read about in the local papers recently. We've had, of course, a lot of antitrust cases. Often there are state claims appended to Sherman Act claims because of the Illinois BRIC indirect purchaser issue. And so we see a lot of that, and there are a lot of data breach privacy litigation where you see both federal and state claims kind of brought together. And this raises a lot of interesting issues, both for you as litigators and for us as judges. And so the 5 topics we're going to try to cover today are personal jurisdiction, because you got to know who do you have jurisdiction over, start with. Subject matter jurisdiction, whether it properly lies in this court. There's a standing issue about class reps, especially if you have multi-state actions and potential subclasses, the issue of sort of headless or partially headless classes or subclasses. And tied to that are questions of choice of law, which is really, really important. For those of you who understand this, it really defines the dimensions of the case, the prospects of class certification, et cetera, and that's a really important topic. And folded into that, and relatedly, is the need for subclasses and whether those are advisable, and if so, how do those proceed? So the first thing I want to, first step, obviously, is personal jurisdiction. Are the proper parties before you? Do we have jurisdiction over all the parties? And I'm going to call on Kevin to kind of address this. I think maybe you're going to talk about the Bristol-Myers Squibb case as kind of one of the landmark cases in the last 10, 15 years that we need to be mindful of.
Thank you, Judge Chen, and good afternoon, everybody. Again, my name is Kevin Budner. I'm a partner at Leaf Razor, and we do all sorts of class actions, and I do a lot of product defect. Congratulations on making it to the last panel and not freezing to death. That's what I was doing. Just for a quick gut check here, how many of you guys practice in class actions in some form of fashion? Well, most of you.
Wow.
Most of you. Okay, so maybe all of this will be familiar to you. Certainly, BMS will be familiar to you, and that's sort of where I'm going to start. So, Bristol Myers Squibb was a decision from 2017, I believe. The underlying facts, very briefly, that a number of plaintiffs sued in California state court against BMS, which is a pharmaceutical company, based on I think it was a blood thinning drug called Plavix. And the plaintiffs included both California residents and not California residents, out-of-state residents. And the question the court was presented with in the first order was, as Judge Chen said, who do I have jurisdiction over? And do I have jurisdiction over BMS, who is not headquartered in California or incorporated in California, and who, yes, does business here? And their first answer to that question was, we have general jurisdiction over BMS because they do a lot of business here. And then the United States Supreme Court decided Daimler, and the California court said, oops, no, we don't. But we have specific jurisdiction over BMS because, again, of all of the activity that they conduct in this state and the similarities between the claims of the out-of-state residents and those of the claims with the in-state residents, the California residents. I both oversimplified and overcomplicated that, but I'm relying on all of you to have a basic knowledge of BMS here. And ultimately, this went up to the United States Supreme Court, and the United States Supreme Court said, okay, we see that you, California court, have specific jurisdiction over the claims of California residents because they purchased Plavix, this drug, in California, and they were injured allegedly in California, and that's enough for a specific jurisdiction. But all you out-of-state residents who don't allege you purchased or were injured in California and who are suing a company who is not at home in California, court doesn't have personal jurisdiction over your claims. And this specific claim-by-claim, state-by-state analysis is required under BMS in at least the mass action context. And it's important as we transition into class actions to note that this was about individual claims that were filed and aggregated, not a representative case. And Justice Sotomayor, I think, was careful to wedge a footnote into her dissent to make clear that it did not address the question of whether the same analysis would apply in a class action. But that was red meat for the defense bar, who immediately did what, Megan?
We got really excited. So, first of all, hi, I'm Megan O'Neill. As Judge Chen said, I'm at a boutique firm that I co-founded about 7 years ago called DTO Law. We have offices here in the Bay Area, LA, and New York, and a substantial part of our practice is class action defense. And so I had been in a big firm for a long time, but I didn't do a ton of class action work. And I really got back into it in 2016. And I remember when this decision came out that all defense counsel got really excited and we all ran into court and filed motions. So we moved for reconsideration. We said there's been a change in the law. We can't have these nationwide classes. And for a while, at least, I can't remember how long, but it felt like we were winning. It felt like, I won a decision. My team in the District of Illinois, people were citing that. And then the tide turned and courts started to say, nope, Bristol Myers doesn't apply. Or there were various approaches, but what the decisions, and then people were waiting for the appellate courts to weigh in. And the Ninth Circuit, interestingly, still has not. And Kevin and I were talking about that. I think that's largely because it's sort of out of vogue. I feel like you hear Bristol Myers and it's like, no, that's so 2018. But it's actually still viable. But what happened was several appellate courts, the Sixth, seventh in DC came out, and then the third, I guess at some point, but all four of them said, shut it down. And the majority, the reason that the thread among all the decisions wasn't this, what I thought was very odd footnote that said this might not apply to class actions. I've never understood that, and doctrinally, I think that's incorrect, because the Rules Enabling Act would say if you can't do it in a mass action, then you can't do it in a class action. So you might hear me refer to the Rules Enabling Act, which, as I was talking to my colleagues, I said, I don't think I ever heard anybody refer to that until I started doing class actions. I don't remember that from law school being emphasized, but we talk about it all the time as defense counsel. But it wasn't the Sotomayor footnote saying, who knows if this applies to class actions. And it wasn't this other puzzling note at the end of the decision about whether it would apply in diversity jurisdiction. What the courts really hung their hats on was the absent class members and saying they're not parties. And so you don't have to do this jurisdictional analysis. And that, if you practice in class actions, as most of you do, it is a puzzling concept, the absent class member. They're sort of in the case, but they're not in the case. So there are all sorts of times that, the plaintiff's counsel doesn't represent them until after the class is certified. So there are differences. There's tolling that applies to them, and there's a bunch of other things that people have pointed to, including the dissent in the DC circuit, where that case was actually the dissent. The judge was very thorough in how he talked about this. But the defense perspective would be there is no difference, that it's sort of form over substance to say if you have an Illinois plaintiff and an Illinois claim, that's different from a plaintiff asserting an Illinois claim against the defendant for jurisdictional purposes. So the defense still can assert this in certain circuits, the ones I didn't mention. But as I said, it fell out of vogue. So I remember seeing this in a recent brief, and I was like, oh, people are still arguing that? Interesting. But it's not because it's not viable or there might not be judges that agree with what I just said. It's somewhat because I think the plaintiffs have pivoted and they are not. I have lots of nationwide classes that are asserted, but they sue in California against a California defendant. So you have general jurisdiction. So you don't have this argument anyway. But that's kind of what happened, is that the tide turned so much that you don't really hear about this as much anymore. But it's live. It's a live issue because the Ninth Circuit never ruled on it.
So what are the implications, Kevin, if in fact there is that Bristol-Myers Squibb applies, it's found by the Supreme Court, contrary to this trend that we're hearing about? What does that mean for nationwide class actions? They all have to be brought only in the home district of the defendant?
Well, that's one answer. And just to sort of caveat where I think the landscape sits currently, everything Megan was discussing applies to nationwide classes, which frankly are hard to bring in their own right for lots of reasons, some of which I think we'll get into today. So currently, the courts of appeal that have spoken on this issue have said a California resident, for example, can bring a nationwide class without requiring of the court a jurisdictional analysis of the residences of all of the unnamed class members in this proposed nationwide class. But what we see a lot of these days, in addition to nationwide classes, are multi-state class cases, right, where a plaintiff's complaint will actually have parties from other out of forum residents who are attempting to bring claims under their state's laws. And if you recall Megan's explanation of why some courts of appeal, all the ones who have decided the issue, have said BMS does not apply in the nationwide class context, that does not carve out actual parties to the litigation. So if you have a named plaintiff, if you're in California and you have a named plaintiff from Colorado, the same BMS specific jurisdiction analysis applies So it's not as if BMS has left class actions untouched. It is certainly it remains a force in that context. But to answer your question more directly, Judge Chen, I think the answer is it does funnel more cases towards defendants' home states, and there are other creative and interesting frontiers in the world of general jurisdiction. So there are ways, I think, to establish general jurisdiction that don't require headquartered or incorporation. One interesting footnote there is the Mallory versus Norfolk case that the Supreme Court decided. I want to say in 2023. We can get into that briefly if it's interesting to folks. Yeah. Okay. So about general jurisdiction, because it's important. I mean, this is really only relevant if you don't want to sue in the defendant's home state, right? If you do, then all of these questions of having plaintiffs from all over the country and going through all of the complicated dance of who has personal jurisdiction over whom, it's resolved if you're in the defendant's home state. But for lots of reasons, many of which I think will be obvious to all of you class action practitioners, that in certain cases that's not the best strategy. In Mallory, the Supreme Court assessed the constitutionality of a Pennsylvania statute that required businesses to consent to general personal jurisdiction when they registered to do business in the state of Pennsylvania. And the Supreme Court, I would say somewhat surprisingly, upheld that law. And that remains good law. If you register to do business in Pennsylvania, you have consented to general jurisdiction there. So, a Colorado or Montana or a Michigan plaintiff can go sue and get a Philadelphia jury if they want. But with, I think, some caveats that case law is likely to face some challenges and evolve over the next few years.
We need a statute first. I mean, California doesn't
have a statute. And as far as I know, only 2 states' statutes have been found to be clear enough, to be express enough about the consent to general jurisdiction that they've been found to pass muster under the Mallory analysis. I think it's Pennsylvania and Georgia.
Can I follow up on a practical question? I thought I heard you say that it's not disputed that BMS applies to named reps of the class. Maybe you have a view on that too?
Well, I think it does.
I mean, if that's so, wouldn't that sort of suggest to the plaintiff's bar, be narrow and instead of bringing in a wide swath of named plaintiffs, which is kind of conventional thinking sometimes, you better concentrate those plaintiffs where you have clear jurisdiction, like California plaintiffs for a nationwide class. Why would you pull in somebody from Colorado or Texas or New York?
Well, Judge Chen, I think that would be an excellent transition to one of our next topics about sister states and headless classes.
Yes.
It can be a bit of a Scylla and Charybdis, a rock and a hard place for plaintiffs. If you have a representative from another state and it creates BMS personal jurisdictional issues, that's one complication. If you try as plaintiffs to advance the claims of a state for which you do not have a representative, a sister state or sometimes a headless class, it's sometimes called, that raises its own set of complications. Some courts have decided that there is that plaintiffs who do not reside in the state for which you are bringing a claim do not have standing to bring those claims, and those claims are in some cases dismissed at a Rule 12 stage. Now, that's not uniformly so, and I suspect Megan and I can have a long conversation about what is appropriate, whether to resolve that issue.
Let's have that
at Rule 12 or Rule 23. It is very much a live decision, so take it away, Megan.
I mean, we're already here, so we might as well talk about it. So I think that one of the things I did want to say, though, even though we reserve time at the end, if anything while we're talking about it comes up, please just raise your hand, because it's sometimes the question feels like we're past it and then you don't ask it at the end. So we're happy to stop and answer it.
Yeah, especially since we got like 5 topics. I'd rather you ask the question.
Exactly. So that is interesting, because I have made and won that argument, and I have made and lost that argument. And district, there's quite a split among the judges on this issue.
Sometimes within one judge, you
Yes, I've also had it where it wasn't you, but you to one of the judges who cited all of her own case law, and then she came out, she rethought it, and then denied it in my case, unfortunately. But what we're talking about, just to situate it, is, so let's say you have a California plaintiff, and they say, I'm going to assert the claims of these 5 other states. And so I've got a multi-state class. And so there's 5 other states, but I'm only a resident of one of them. And the argument is that because Article 3 standing is claim by claim, per Daimler, the Supreme Court decision, that California plaintiff does not have standing to assert those different 5, we're talking about state laws. So you've got Michigan, Illinois, all these other states, they don't have standing to assert those claims. Now, I feel to me that is clean, and so I like that. So I've argued that. Some judges embrace it and say yes. But then other judges have said, and because I practice, I have several cases in New York. In the Second Circuit, this is not widely considered at the Rule 12 stage. It pretty much is always pushed to class certification. But in the Ninth, like I said, there's a lot of different opinions about how to do this among the judges in all the districts. So what the courts would say is either we'll get to that issue later, and perhaps it's premature to raise that now. Or this isn't a Rule 12 issue, period. And this is a predominance issue. So you see, I agree with you, counsel, and we're going to just have a California class under California claims. So that decision, like I said, courts have handled it different ways. Sometimes the pleading is not clear as to what they are pleading in terms of what states. And I would say the plaintiffs' bar have made it harder to sometimes, they sort of made it a little murky, and it's hard to figure out what they're alleging. And that actually makes it sometimes harder. Some judges push back on that and some don't. And so, but when it is played that way, and you can say that you have no standing for these claims, I think most of the defense perspective is the time to do that is upfront, because what would change? So predominance to me is a different inquiry, and that gets into Maza, and I think we can talk about that. But I see this as a standing issue, standing at the front end. Look at it there, because why would a California plaintiff ever have standing to assert that Illinois consumer protection claim that only covers Illinois residents? So figure that out up front. There are some interesting discussions in the case law about, we'll sort of let that go through and we'll figure it out later. And that there's not a big downside to that, because we can just figure it out later. And I thought it was interesting because from the defense perspective, it's very important that you know that in the front end. And I think that it could be very bad for both sides to not know that, because if you, for example, as some judges have suggested, cabin discovery, let's say you say, okay, I know you have a California plaintiff, unclear what's going to happen, I'm going to make discovery limited. But what happens if you certify a class nationwide? Did you go do the discovery then? That seems like duplicative. Do I have to produce my 30B6 witnesses all over again on what the advertising was outside of California? So I can see, I don't want widespread discovery on something that's expensive, it's time consuming. But I think for everybody's sake, I do think it is better to figure out as much as possible at the pleading stage. And I know that is not shared by most of the judges, but from the outside counsel perspective, I think that's really important.
I take it you don't share that.
I have a different perspective. So think of it this way, all right? You have two residents, two people, one in California and one in Nevada, and they are hurt by the same product in the same way. They have, let's say their consumer protection laws are written almost identically, right? They have very similar claims, but they are in two different states, right? The standing analysis, and the California plaintiff brings suit in California, endeavoring to represent both the California class and the Nevada class, okay? The standing analysis is whether this plaintiff has standing to bring claims, right? That's the question. Question one, do you have standing to be in court, right? Does this California plaintiff have standing? Absolutely. And the next question is, what do you do with the fact that there are differences between your claims, the claims that you personally have, right, and some of these other claims that you are seeking to represent? And what the Ninth Circuit has said in a pretty similar context in a case called Melendres v. Arpaio, actually a case that came up a few panels ago, is those factual differences, those could be relevant to whether a class can be certified. They may be relevant in the holistic Rule 23 analysis of adequacy, typicality, predominance, etc. But they're not questions of standing. And we don't have to resolve them in a binary way at a Rule 12 posture. It just doesn't make sense. That's not what they're here for. Standing is we're assessing the standing of the plaintiffs. Plaintiffs have standing. Can they represent other claims for unnamed class members in other states? We'll figure that out when we get to Rule 23. Now, even with that guidance from the Ninth Circuit, the courts in this district are as split as I have seen them on any issue. I mean, they are really, you have 4 judges on one side and 4 judges on another, and some judges that are on both sides, because it's complicated. And the judges who view it as a standing way say, okay, well, Melendres was talking about differences in different kinds of injury, not differences in which laws you're bringing. And the ones on the other side say, well, that doesn't matter. They said any differences, deal with it in the Rule 23 context. And that, it really was a conceptual distinction that matters. From the plaintiff's perspective, it's not just kicking the can down 6 months and reaching the same conclusion 6 months later. It's a different analysis, and one I think that is more appropriate in these circumstances.
What's your response to Megan's point about judicial economy or just general economy that have to decide these things later? Do you do mass discovery now or wait and then you reinvent the wheel later? I mean, what's your response to the need and the benefit of having this decided one way or the other in a timely fashion?
I think my answer would be if it were the same analysis at the plea, at motion to dismiss, as it were at motion to class certification, then by all means, let's get it done early. But it's not. It's a different analysis. It's a different set of questions when you're analyzing it in a more holistic Rule 23 framework. So even if I think the answer could be different depending on where you place it, but to the question of efficiency generally, I often will press defendants to identify real differences, like material differences in the scope of discovery in a class action about defendants' products and defendants' practices, many of which are nationwide. I think in most cases, not all, in most cases, they will struggle to identify a real difference between California discovery and Nevada discovery in a consumer defect case, in the kinds of cases, at least, that I litigate.
Can I give you a real world example?
I hope you do.
So when I don't think I told you what kind of work I do, but I defend a lot of false advertising class actions. I do a lot of other I've done other types of class actions, but largely if someone is complaining about the representation on a label, that's generally, that's right in my wheelhouse. So what you see, a lot of the clients that I represent are manufacturers. So they don't sell directly to consumers. So when you have a nationwide class, they're well aware of certain sales that go out. They usually, the stream is very well understood by country. So they know what they've sold in the United States. They do not know what they have sold in California. They often know what leaves their headquarters or wherever their manufacturing is and lands in a warehouse. And from there, it goes a bunch of different places and people buy at different places. If you are doing discovery on nationwide sales, you present a witness and they have your sales on all the sales in the country. Now we get to certification. And the court determines that you can't because of predominance. Now this is a case where we did not have, it was a resident defendant. So, and so in California plaintiff, but says that you can't have a multi-state because of the differences in the state laws based on Maza. And is everybody familiar with Maza? Okay, so Maza is a case from, I think, oh gosh, let me get the year, 2012? Okay, good. Maza versus American Honda. And that case as a Ninth Circuit decision. And it was where the district court found that the differences in the state laws were not material, so that you could apply California law to everyone's claims across the country. And the Ninth Circuit said, no, that there are material differences in Reliance and Sienter. And so those differences among the consumer protection laws are material. And therefore, under the governmental interest test, which is how California's choice of law test is conducted, the place of the wrong is what is key. And it's when the person bought the car and they saw the representation, they bought the car, they were in their home state or maybe adjacent to their home state, but they weren't in California. And those other states have the predominant interest, not California. And Maza has been applied left and right. This is, when we talk about the defense gets excited about decisions. We don't have that many of them in the Ninth Circuit. So Maza is one that we cite a lot. And so district courts are probably really sick of hearing us cite it, but we cite it all the time because it's got some good language. But this decision was very important because what happened is people started to cite because the court did a choice of law analysis. They've said, look, the Ninth Circuit has already decided this issue. So at the pleading stage, just apply Maza. We know it's not going to be California law. So when the plaintiff says California law, but multi-state class, say no, it's not going to be California law for the Michigan plaintiffs. We all know this. Can we just decide it now? But courts often say no. I'm not doing it now. I'll do that analysis later. When they do that, I'm saying here's the real world example. You end up in this world where if after class certification, you end up with a California only class, which Kevin's pointed out is very hard to certify a nationwide class. So you end up with this, let's say one state. Now, how do we identify what the sales were in California? That's a whole nother endeavor. It's completely different from what we looked at. So it's just one example, but it would have been more efficient to do the entire time, to just say, okay, we're going to figure this out. Because the answer may be that impacts materially whether the class can even be certified in the first place. Because this is a real issue. But we didn't even look at it. And then we're on maybe you're going to have to move to decertify. And that's a long road. So if we could figure this choice of law out at the front end, because I did commercial litigation for about a decade before I did class actions. And I don't ever remember being in a case where I didn't know what law applied. I feel like that's always a threshold issue. What law applies? We figure it out immediately. But in class actions, it's often pushed off to class certification. And from my perspective, that just doesn't make sense.
How does determining which law applies affect Article 3 standing?
So it wouldn't, except that often it's pled as I'm going to represent a multi-state class. I'm going to represent the residents of these other states applying California law. So once the court does the choice of law analysis, they determine that if you're going to have classes in those other states, they will have to be under the laws of those states. And then the standing analysis comes into play because you need a class representative for those particular state claims.
Megan, are you bringing motions to strike at the pleading stage class allegations? I'm beginning to see some of those. It's one way to advance the ball on, if you don't buy into the Article 3 standing questions, all right, it's a question of Rule 23. Have you been bringing those?
So I might start to again, because I was just in preparing for this, I saw Judge Chowdhury, a decision from 2020. I have to say, I did bring them, and they were sort of uniformly denied with some real negative reaction by the judges, like, what are you doing? You know, that these are disfavored. Why, this is a Rule 23 issue. And that, you know, whether you can have a class action or not, to me, that made sense. Okay, so we're going to wait for class action. We're going to wait for class certification. So I got sort of knocked down on that several times, and I stopped doing it. But I was looking at, because I saw it the way I just described it, that made more sense to me. But, you know, you got to get with whatever the judges are going for. And if the judges are going for a motion to strike class allegations, I'm not going to stand on my principles and say, this really should be a standing issue. Let me do that. If I'm going to lose on that, I'm going to go with a motion to strike class allegations. What do you think?
Your Honor, may be heard.
Yes, you may be.
I do feel like I'm in a discovery hearing all of a sudden.
Well,
Listen, I think there are reasons why there is no consensus on this issue. It's complicated. There's lots of ways to look at this. The situation that I think we started talking about was where you have multiple states' laws in play, right? And using the example, a California plaintiff who is suing on behalf of his or her own class of California absent class members and absent class members in other states who have state claims under their other states' laws. And in that context, I think at least in the Ninth Circuit, my view is Melendres v. Arpaio says that's a question whether the California plaintiff can represent those other plaintiffs and their states' laws is one that should be decided in the Rule 23 analysis. So it doesn't mean that class can always be certified, right? Sometimes the Rule 23 factors will point in one way, sometimes they'll point another way. You got into Massa, which is I think an interesting transition because Massa reflects reflects sort of another strategic approach to this issue, which is, well, instead of dealing with the complications of having every state's laws in play, let's pick one state and apply it to everyone. And that's what was happening in Massa. The plaintiff said, well, let's just take California law and apply it to everyone in the whole country. And then we can have a nationwide class. And we don't need a federal claim for it. We'll just take California's laws and apply it everywhere. And it is true that under California's choice of law analysis, the Ninth Circuit said, step one, identify if there are conflicts between the laws of the various states. Okay, step two, determine whether those conflicts are material, and then you go into the interests analysis to see which state's laws should apply. And the court identified some differences that would make it difficult to apply one state's law to everybody in the whole nation. But I don't think that really affects the question of whether you might be able to certify a class of a California plaintiff seeking to represent California state law claims and other states as well. And it also has given rise to some pretty interesting case law where plaintiffs have fashioned classes that are grouped along certain contours of different laws. So the differences that were deemed to be material in Massa were reliance versus non-reliance. What was the other one? Let's just take that. Scienter or non-scienter. So all right, well, if you can't certify a class where there are those kinds of differences, if there are conflicts between those kinds of laws, well, why don't we just group them? Let's have a class of the reliant states and another of the non-reliant states. Let's have a scienter class and a non-scienter class. So there are still ways to make aggregate litigation more efficient and ultimately And I think that is what we're trying to accomplish here, right? For both plaintiffs and defendants, right? Is to find a way to take a lot of claims, which could lead to a lot of different results, and funnel them into a more efficient and orderly fashion.
So let's say you do that and you have subclasses based on type of theories that are similar, which I've done in several cases. And when you look at 35 different states, in the end, you realize there's maybe 3 groupings or 4 groupings. What about going back to the original question? Can a California plaintiff fairly represent, whether it's by way of Article 3 standing or by way of adequacy of representation of Rule 23, people in a state where they require reliance?
I think in that context, if you're advancing subclasses because of those distinctions, I think I have to concede you're going to need a representative for each subclass.
You don't disagree with that, I take it.
I try to make reasonable.
I do not disagree. Yeah, I know. I mean, all of these things become very interesting. My firm tried a class action on behalf of Honda in front of Judge Alsup a couple of years ago, and that you have a class action trial is when you really see how complex this can be, and when you at the front end of the case, this is true for whenever you get to a trial for the first time. I feel like the first time I did a trial, all of a sudden I was like terrified thinking about what I had written in the interrogatories that I thought were meaningless as an associate, and suddenly it's everything in the case, and you're so nervous about it. And now you view the case differently from the beginning. Well, the same thing was true after we did that trial, because class action trials are incredibly rare. And after that, just sort of thinking about the trial plan and all these things of ways to sort of tell the court why this is so complicated. And sometimes it is this issue with the differences in the laws, because sometimes they're very different. And how would you present that to the jury? You heard this thing, and then, because this goes beyond jurisdictional issues, but on choice of law, it's really important, because the law can be very different and in very material ways, and you can have 2 different outcomes. We had a California class and an Illinois class, and the jury found that there was liability in Illinois, but not in California, because the laws were that different in the same trial. So I do think the differences matter, and they can matter very much. So that's why looking at the choice of law sooner rather than later makes sense. And I think that we talked about when you have one representative, what happens. But you could have, there's this desire to do it all in one. There are times where people do single state, class actions, and then you have an MDL. So it's not as though there's no mechanism for this, but in my practice, I see a lot of nationwide class actions, and they don't really get resolved until class certification. The majority of them remain either a multi-state or a nationwide until later. And like I said, I think there are a lot of problems to that.
I'll just add an editorial comment from the judicial perspective. I think as my colleagues are beginning to see more and more cases actually go to trial, I think all of us have now had class action trials. And one year I actually had 3 go to verdict, which is very unusual. In 23 years before that, never had 1 go to verdict. But I had the same experience you did, and that is, when you certify the class, when you're dealing with motion to dismiss, et cetera, you don't really fully appreciate all the contours, the complications, especially if you have multi-state. And so now my practice will be, and I think some of my other colleagues agree, when we get to the class cert stage, I'm probably going to be asking for a detailed trial plan, and I want to see what the verdict form. I want to see what the instructions look like on the critical issues, and I want to see what that verdict form looks like. Because if you have a matrix of 35, imagine if you have 30 different states and you have 3 versions of an engine that are at issue, and you have different classes. You got a matrix that's like 15 pages long. Is that manageable? Is that really a good way? And maybe it is. Maybe if you group things in a certain way, it makes the litigants and the court think forward as to how it would actually play out. And so, Kevin, your thought about grouping things. I mean, there are ways of making things that seem insurmountable, surmountable, but sometimes they're not so surmountable.
I can't speak for the whole plaintiff's bar here, but I would say generally, I welcome that. I think that class certification is a good opportunity to be talking about trial plan, and we should all be prepared for that. And it's a good opportunity for all the parties to really tighten the screws on what the scope of the case can and should be. I suppose, though, that I would also note that, notwithstanding the fact that large class actions can be complicated, especially as they move through the latter stages of their life cycle, I think the superiority analysis requires everyone to contemplate the alternative, right? Is that complicated? Sure. Is it more complicated than if they get splintered out and there's,
And that was
several
going to
different
be my
trials?
question to you. Maybe would you like 30 different class actions in 30 different states as opposed to having one?
Yeah, that's a pick your poison situation, right? I think, what I've seen is that most of the time the case is cut down to one state. It becomes manageable to settle or to try. So sometimes companies, absolutely right, they did nothing wrong. What's happening is if you are facing an enormous verdict, if you lost, nobody wants to roll that dice. So there's a settlement. And that is the settlement piece of the class action world is, I think, why jurisprudence has evolved the way it has, is that when I did a presentation on class action trials and in the consumer packaged goods context. So not cars, and it was, I think I found 3 or 4 over a decade. I mean, it was so difficult to find any of those because they all settle. On cars, sometimes those go to trial, and that's because a car is really expensive. So you are talking about, even in a settlement, it can be really huge. But a consumer product that costs $20, the settlement number can be approachable. The verdict is not. So what happened over the years is that people just assumed, meaning I think the judges, if I'm a judge and I'm sitting in the Northern District of California flooded with class actions, I know what happens after certification is usually they end. So at some point they end and they don't make it to trial. So it's an extremely small percentage. And we all know very few cases go to trial overall, but in class actions, it's this small. So a lot of decisions just got punted because why does it matter? You're going to settle the case anyway. In practical terms, we get to class certification, we settle. But if you have a trial in court, like Judge Chabria has a trial plan requirement as part of certification, and I think that's great when judges do that. But I think if you look at the trial plan, that makes a difference. But I think it's really important that there's a recognition that we should narrow it to whatever it could be ultimately. If it can't be a nationwide, do it now. Because a one state class, some people will try. And the case that we tried is a great example because it actually got culled down from this to this. And so it was nationwide and it was very broad. But when it went to trial, it was actually not a huge case money-wise. Most companies will not try. I know everybody's like, oh, who cares, right? Like what companies, but it's in terms of actually getting the focus on where it should be. I would like to see things get tried. I would like companies to see this. This is an important vehicle. There were times before we had this that companies were doing things wrong and there was no way to right the ship because they're at their $20 claim. Now companies are held accountable. But I think it's gone far too far the other way, where you get this suit and it's sort of like people on the company level, it sort of feels like extortion. Anybody just says, I think you did something wrong, and if you fight me, it's going to cost $2 million. People, that's why so many cases settle. You had a question? I think it helps defeat certification. So I'm biased from the perspective of I want it because but I think it saves people trouble. So to Kevin's point, like if I'm on the plaintiff's side, I don't want to put in a lot of work if the case, I'm not getting paid by the hour. right? The defense bar is getting paid by the hour. So I don't want to put in all this work and then lose later on an issue that could have, the judge saw it earlier, would have said, no, or change your theory. You know what? You got to pivot. This isn't going to work. I would rather know that up front because my time is valuable. I've got a lot of other cases that I could manage. So a trial plan, I think, helps orient the parties of, is this triable? Is this certifiable? And sometimes there are really glaring things, but it's very hard when the court has the docket that it has to see the things that you see when you're in the, you're in the trees, right? And you can see all of it. So I think I think it would be helpful to cut things down sooner because there are just too many class actions at this point.
We're going to take questions, but I have one question for both of you. Where you have a large multi-state kind of action, have you ever suggested or tried kind of a bellwether approach to say, well, let's take the California case, let's take that to trial and maybe use that. It's like they use bellwether in mass tort cases, as opposed to trying to go to trial with 15 different state laws.
Absolutely, it happens. I have been involved in a bellwether trial, but not in a single state class action context. But it definitely happens, and it can really be an efficient way to address and really figure out what's manageable. If you start one state or maybe a small group of states, it does have potential because I think the reality is what both of you articulated, which is that, yeah, some of these cases are getting tried now. And that's, from my perspective, not a bad thing. And it's good for both plaintiff and defense bar to be thinking about efficient ways, and of course the judiciary to be thinking about efficient ways to do that. And bellwethers have a role to play.
Yeah, I agree.
Good. Any questions? We got 5 minutes, 6 minutes before we engage ourselves into the next adventure, which is reception. But must have some questions, I hope. No?
Well, I took the opportunity to say that, Megan, when you said flooded with class actions, you meant blessed with an abundance of class actions.
There's so many. I just think if I were a judge, I would be really tired of them really fast. So I think there are just so many. So it's interesting because when I think I did my first class action in 2003, and I remember I was working with this partner, and he was like the guy in LA for class action defense. And people were like, he's the guy. There is no such person anymore. I mean, there are so many specialties within class actions, but there also are just so many people doing it. But back then it was kind of like, we're doing this area of law called class actions. And it did not feel, I almost tried a class action, and I can't remember what year it was, but I was at a firm known for its trials. And we were hard pressed to figure out, we couldn't find anyone who had done a class action trial. We were calling and asking, we were calling librarians, because that's how long ago it was, to ask, was there a book that told you, like, who are the witnesses? What happens? Everyone, even the most seasoned trial lawyers who had done, 85 trials, had no idea what would this look like. And so, that's 20 years ago, but that's not that long in the span to see what has happened from there till now. So I would like to see some reform and some changes, just because I think there's just it's too much at this point. And I think you want to clear the decks, and some absolutely should exist, but not at this level.
I will say that, when I had my first 2 or 3 class action cases, there were some basic questions I didn't know the answer to. Like, what do you instruct the jury as to when you generalize the evidence and testimony of the class rep to the entire class? Can you is there a presumption that what they experience, or do you have to back that up with some data to show that you can generalize it to that? You have to show independent, you have to do a sampling to show. How do you do that? And there's one instruction, I'm not even sure it's a model instruction, I found it somewhere. It just says, when appropriate. I said, okay, I'll just give that one. Can't go wrong with that.
Settled either. I think because there have been arguments I've made where judges have said, argue that to the jury. And I say, argue that there's heterogeneity among the class to the jury. That feels like a motion for decertification to the court. And we'll say that person doesn't represent the class. And so I do think there isn't a bright line rule yet because nobody has spoken and say at the appellate level. I think it's very confusing, even conceptually, to think about how one person can sit and speak for millions of people. And you must apply that to all those millions.
So I guess I would acknowledge that there can be some uncertainty in class action trials, as there are in many trials, but I see that uncertainty as an opportunity for us on both sides of the class action bar and judiciary, for an opportunity for creativity and an opportunity for discretion in fashioning relief in what can be really important and wide-reaching cases. And I guess I would harken back to the point I made earlier, which is, yeah, it's complicated. I mean, you're talking about claims of potentially millions of people, but wouldn't you rather have them in one court rather than a million? I mean, and if your alternatives to say, well, they wouldn't bring their cases if they were splintered. Well, but that's the whole point of a class action, right? Is to offer some sort of aggregate relief for litigants who might otherwise be barred by virtue of the relative expense of litigation.
There's also the argument that in the end, it can be beneficial to the defendant. If the defendant prevails, you have a binding, you win, and you're binding everybody in the class. If you do it one at a time, you can win one at a time, but
I'm saying you gotta have a real strong stomach.
well, that's right.
The stakes are high. The billions could be on the line. And so, yeah.
Interesting. Any questions? Got to be another question out there. We got a question. Well, I think Kevin touched on this from the plaintiff side. The more you can simplify the case, the better. I've seen cases, maybe you give up some claims. Maybe you give up. I mean, you see this in the damages area, right? In order to get a model that works for the whole class in a consumer case, you go to the benefit of the bargain theory that, I overpaid at the beginning as opposed to consequential damages. So, you have to think things through. How do you make it simplified? Do you group things? Do you really want to advance 30 different, state laws? Is there a way to do it? And that's what I think, looking ahead at what the jury verdict, because I think that's a lot to ask for a jury verdict. I mean, I have here my HIV antitrust thing I just looked at, big class action. And, that was like 14 pages long with just fine print. And it's like, is that what you really want to present to the jury? And sometimes you can't, but I think if you, at least on the plaintiff side, if you think ahead and maybe use some judgment about maybe giving up some things and making things a priority, and then making it clear to the court it's a doable plan, I think you advance the ball. Any other questions? Well, we're at 5:30. It's Miller time.
Miller time.
All right.